In India, the social contract of growing old is practically written into our cultural DNA. We operate on a deep-rooted assumption that when parents age, their children and extended family will step in to care for them. It's an unspoken agreement that acts as a substitute for a robust social safety net. But what happens when that traditional family structure suddenly breaks down? For many, the safety net shatters entirely. A recent ruling by the Allahabad High Court forces us to look closely at what happens when these cultural expectations collide with the rigid reality of the law. The court's ruling is stark and uncompromising. An earning, widowed daughter-in-law has absolutely zero legal obligation to financially support her dependent elderly in-laws. This ruling creates a direct friction between what we assume is a moral absolute and what is actually written in the legal code. It forces a confrontation with the limits of our cultural expectations. The dispute reveals the specific mechanism of how senior citizens lose their legal standing the moment a primary breadwinner is gone. Relying on traditional morality to survive in your old age is no longer a safety net. It is a systemic gamble. And as this case shows, it's a gamble that leaves India's elderly completely vulnerable to abandonment when tragedy strikes. To understand how the legal system processes this vulnerability, look at the petitioners, an elderly, illiterate couple living in Agra. Like millions of Indian parents, they had no independent retirement fund. They were entirely, completely reliant on a single source of income, their son. Their son was a Uttar Pradesh police constable. For a time, his income provided stability. But in 2021, he passed away, removing the family's only financial pillar. Following his death, his widow, the couple's daughter-in-law, began receiving government benefits and secured a job of her own. Seeing her as the new earning member of the household, the aging parents went to court. They argued that she should now assume her late husband's financial duties and provide them with a monthly maintenance allowance. The parents specifically alleged that their daughter-in-law secured her new employment on compassionate grounds, a legal provision where the government gives a job to a deceased employee's dependent to prevent the family from falling into destitution. But the family court in Agra rejected their plea in August 2023. The judge noted a lack of documentary evidence proving she got the job specifically on those compassionate grounds. Left with no other options, the desperate parents appealed to the Allahabad High Court. The parents built their entire legal strategy on a desperate assumption of family duty. They expected the court to enforce a moral obligation. But the Indian legal system is simply not designed to recognize morality without a specific statute to back it up. The parents filed their claim under Section 125 of the Criminal Procedure Code, which has now been updated as Section 144 of the Bharatiya Nagarik Suraksha Sanhita, or BNSS. This is the specific law in India that governs the right to claim financial maintenance from a family member. The flowchart shows exactly how Section 144 is written, listing those legally allowed to demand maintenance: wife, children, and parents. The text stops here. The category for parents-in-law is completely absent. They are effectively invisible to this law. This absence is exactly why Justice Madan Pal Singh dismissed the appeal. He pointed out that the right to claim maintenance is strictly a statutory right. If your specific relationship isn't written in the legal code, you cannot force someone to pay you. The judge made a stark declaration: compassion and sympathy have zero legal standing. A court cannot force a citizen to financially support someone based purely on moral decency. The court clarified a crucial distinction. Claiming a share of the deceased son's inheritance or property is an entirely separate legal process. But forcing a widowed daughter-in-law to carve out a monthly maintenance check from her own independently earned personal income, the law simply does not allow it. The legal system operates as a rigid, unfeeling machine. It reads the text exactly as written. If you aren't explicitly named in the code, your moral right to survive simply doesn't exist in the eyes of the state. This is not an isolated incident. 2 years ago, the Bombay High Court handed down an almost identical ruling, rejecting another elderly couple's demand for maintenance from their widowed daughter-in-law. These cases reflect a broader cycle. Parents liquidate their assets to fund their children's advancement, trading their personal financial security for the promise of future care. When that single pillar of support collapses, whether through death or estrangement, the elders are left stranded. The state provides inadequate social security, and as we've just seen, the courts offer zero legal leverage over remaining extended family members. It is easy to look for a villain, but the daughter-in-law here isn't breaking any rules. She is operating within the lawful boundaries of her statutory obligations. She owes no legal debt. The real issue is a systemic failure. India has a legal structure that has not evolved to protect its aging population independently. It outsourced elder care to family tradition and never wrote a backup plan into the law. It forces us to ask, can a nation truly claim to revere its elders if its legal system treats them as completely invisible the moment their direct offspring are gone? Until statutory laws are rewritten to provide independent, robust, and state-backed protections for senior citizens, their right to survive old age remains a tragic illusion, one that is entirely dependent on the mercy of others.